Hi, everyone. My name is Stephen Davis, and I'm an attorney with Carmody McDonald. I'm also a member of our Condominium and Homeowner Association practice group. Thank you for inviting me to speak for CPM's Best Practices Library. For this session, we're going to talk about a new statute that's just come into recently been signed off on by Missouri's governor. That's Section 442.404, dealing with political signs, solar panels, and sale signs. The political sign statute actually already existed, and these were two new additions to it. But since they're all in the same statute, we're going to talk about this at a higher level together. And I just want to point out that we're going to talk more about the higher points today, and that for anything more specific or any further action that your community may want to take, it's important always to contact your association's attorney for a more in-depth review and a further discussion of the issues to make sure you're doing what's best for your community or the community that you're managing. Without discussing further, at this point, let's jump right in and get to the first part of this statute. So again, this is Section 442.404, and in August of 2018, the legislature put into effect this political sign statute. And so we've had a couple election cycles now to deal with this statute, and me and others, we put articles and have spoken about this statute before to make sure that boards were aware of it. I think the high level advice I want to give everybody is please take the actions ahead of time to put any sort of rules into effect now, before the election begins. And where we're sitting now in August of 2022, we are obviously have an upcoming, we're in the middle of an election cycle. We've had primaries, but we're have an upcoming general election. And so rather than being responsive to any sort of situation that arises, it's important that we take those steps ahead of time so that we're addressing it and have a rule in place to enforce. That goes a long way to making sure all owners know what the rules of the road are, and avoids it seeming like you may be kind of singling somebody out or going after them for their own political beliefs, rather than really trying to equally enforce a restriction against all owners. And so this is the older language of the statute that's in effect, and I'll just talk, rather than go into detail on let's talk about this first, since this is in effect right now. The changes we're going to talk about and see in a minute aren't in effect until January 1st of 2023, although they're already signed off on by the governor. Since we will have some people viewing this for the upcoming election now, I want you to see what's in effect at this time. So important to point out that this is a statute dealing only with homeowners associations as defined by the statute. We're not talking about condominiums. We're only talking about homeowners associations, which are defined here as nonprofit corporations or unincorporated associations of homeowners created under a declaration to own and operate portions of a planned community or other residential subdivision that has power under declaration to assess association members, and you can read the rest here. But I think the important point about this is the reason we're dealing with a homeowners association is because in this situation, oftentimes owners own a lot and have control of the yard in front of their home, as opposed to a condominium association where usually, the owner does not own that outside property, and so it would be inappropriate for them to be placing political signs on property that's owned in common. And so what the statute goes on to talk about is it defines what a political sign is, and this is really important because a political sign is defined as a fixed ground-mounted display in support of or in opposition to a person seeking elected office or a ballot measure, excluding any materials that may be attached. Okay, so what's being legislated here are those ground-mounted displays. So we're talking about a ground-mounted sign, not a flag or some other memorabilia that you see, or not anything attached to a sign. And we're talking about somebody that's on someone seeking elected office, so something that's on the ballot, running for office, or a ballot measure, someone an issue that's on the ballot. We're not talking about the other issues that we may see people around town have signs or flags for dealing with political issues or other issues of the day. That's not what this statute is regulating. And so looking down, we're talking about what it says is you can't have a deed restriction, so you can't have something in your declaration or indenture for your community that prohibits or has the effect of prohibiting political signs. So what that means is if you've got a sign restriction in your indenture, that sign restriction is valid, but you have to allow for political signs based upon this statute. You can't totally rule them out based upon a sign restriction. And that actually was the law before this statute went in place. The law that there was no statute that regulated it, but the case law in Missouri controlled and said that you did have to allow political signs as a speech right that we all have. But what this statute does do is it allows your association to put rules in place to restrict political signs. And it says you can restrict the time, size, place, number, and manner of display of signs. So usually what I see communities asking us for is helping with developing a rule that limits the size of the signs, usually restricting it to the normal size lawn sign that you see and not the jumbo ones, a certain time frame before and after a primary or before and after the general election or any runoff, and the number of signs that can be placed in the yard. And also that those signs are limited to actual signs. They don't play music. They don't have attachments, all those sorts of things, really to, ultimately to maintain some semblance of order in the community that I know many of our boards are looking to preserve while also allowing people to express their political beliefs. The next part, number 4 in this statute, talks about your ability to, as the board, to remove a political sign if it's in the common ground or otherwise threatens public health or safety, violates a statute or ordinance, or is accompanied by sound or music, or if there are materials attached. So you can remove it if it violates in those areas. And I think the main thing that we're dealing with public health and safety, although I'm sure there's others, are signs that maybe block the visibility at an intersection of the street in some way that it would obstruct sight lines and potentially be harmful to drivers or pedestrians as a result. Or maybe a driveway, someone leaving the home may not be able to see traffic or pedestrians or others in the street or the sidewalks that could cause a problem. So it does say you can't remove it from the property of a homeowner or impose any fine or penalty unless it is given the homeowner 3 days written notice, which should provide that. So it's saying that you can take action or impose a fine or other penalty if you've provided that notice first. So let's move on from there. I'd usually pause for a discussion on political signs and all the various issues that I know you have questions on, but let's move on to the new statute that's effective January 1st of 2023. And actually, before we do that, I do want to emphasize, let's go ahead and, again, like the advice at the beginning, and put those rules in place now. I know we're getting very close and we don't have a lot of time before an upcoming election, but it's very helpful from a notice point of view and an enforcement point of view that owners know what the rules of the road are for your subdivision as far as displaying their support or opposition to a candidate or a ballot measure. So the statute's been changed by the legislature and signed off by the governor. That'll be effective January 1st of 2023. And we've got this new language here about a solar panel or solar collector. And so this new statute addresses solar panels and sale signs. And we've already seen a number of communities want to talk about solar panels and new solar rules and for sale signs in their communities. So it defines solar panel or solar collector as a device used to collect or convert solar energy. There's some technical terms there, but I think we generally know what is meant by that. And so this is that statute that we saw before dealing with political signs that we just spoke about. So that statute remains in effect. but it is now added. There's two other provisions that have been added to this statute, and it's been a little bit reorganized in some ways. So number three here is where we start to talk about solar panels, and it says that your deed restrictions, covenants, and etc., your indenture can't have the effect. You can't limit or prohibit or have the effect of limiting or prohibiting the installation of solar panels or solar collectors on the rooftop of any property or structure. So important to note there is we're talking about the rooftop of a property or structure in a homeowners association, that roof being property that's owned by the individual owner. And actually that's sub 3 below. Only with regard to rooftops that are owned, controlled, and maintained by the owner of the individual property or structure. And that's obviously very important, right? Because we do have homeowner associations, specifically often in villa communities that are HOAs, where the roof may be maintained by the association. And so that this statute does not prohibit or does not allow for the installation of solar panels by an owner on a rooftop that the association maintains. We can have a separate conversation about solar panels and rooftops the association maintains, but this is only, I own my home, I have to maintain and control that roof, and so I have the right now to install solar panels on that roof if that's the case. However, the statute goes on to say that a homeowners association may adopt reasonable rules regarding the placement of solar panels or solar collectors to the extent that they do not prevent the installation of the device, impair the functioning of the device, restrict the use of the device, or adversely affect the cost or efficiency of the device. And so I think where we see this playing out most likely is many communities that we've worked with over the years have said, we don't want the panels to be visible from the street. And what that usually means is the panels need to they need to be rear facing, not on the front side of the house. And what this provision is saying is you can have rules, and you perhaps, we haven't seen what the enforcement of this is going to look like yet, since it's not yet effective. But you may still be able to say, here's our preference. We'd like these on the rear, a non-street facing side of the roof. However, if the contractor that's installing the solar panels comes back and says that these solar panels need to be on the street facing or front side of the house because of the angle of the roof and the sun, and give you a reason for it, that the association at that point is ultimately, per the provision here, is going to need to allow that front facing or street facing solar panel, because otherwise would impair the functioning of the device or restrict the use of the device, or adversely perhaps affect the cost or efficiency of the device. There may likely be other areas where this issue would come into effect, and we're going to see that as we move forward, but that's what we suspect will be one of the major changes for many of the communities we work with. But again, we have this coming down the road very soon in January of 2023, so now is a great time for boards to really go ahead and start figuring out what they want those rules to look like when this statute goes into effect. Because even with solar panel requests now that you may be receiving, it may be to the board's benefit to go ahead and have a rule in effect that would comply with this statute, so that you can work with your owners rather than saying, well, here's the rule now, and we'll see it in 4 months. I think we've been working on rules under this new statute for other communities we work with, and we suggest and recommend that if solar panels are an interest in your community, going ahead and getting a head start on that, and getting a rule in place and providing a process for solar panels. This last slide now is on sale signs, and this is another change that goes into effect on January 1st of next year. And this is another response to restrictions in indentures that say that you can't have any signs. And what this statute says is that your indenture has to allow the display of sale signs on the property of a homeowner or property owner, including but not limited to any yard on the property or nearby street corners. So what this is saying is you have to allow a sale sign on in that owner's yard and on nearby street corners. You can't prohibit that, but you do have the authority again to adopt rules subject to any applicable statutes or ordinance regarding the time, size, place, number, and manner of display of sale signs. So, like we talked about with political signs, you could, have limitations on the number of signs, the time, place, where they should be, that sort of thing. But you can't prohibit it. You have to allow that display. Again, we have language talking about removal of those sale signs if it's placed within the common ground, threatens public health or safety, violates an applicable statute or ordinance, accompanied by sound or music, or if other materials are attached to the sale sign. So I know we do see a lot of sale signs that have attached flyers or something like that from the realtor. That's not permitted by this statute. I think there's also, we may see some development of an issue here where this is saying that you can remove a sign if it's on the common ground, but it also says they can be placed on nearby street corners. So if that street corner is a common ground, there may be a conflict there. If that street corner is owned by another homeowner, I could see an owner-to-owner issue, but the statute does allow specifically for placement on nearby street corners. So it may be to the benefit of the association to have some clarity with its rules for what placements are allowed or not allowed that are not on the individual owner's property, in addition to other rules in compliance with this statute. And it does say, again, that subject to this, the association shall not remove, a sale sign from the property of a homeowner or property owner or impose a fine or penalty unless it has given the owner 3 business days notice from the association. So you can have fines or penalties, and you can remove signs that are not proper per the statute if you provide the proper notice as required here. So again, like the others, we recommend that you take steps to put a clear rule in place so owners know now, but also when this rule the statute soon becomes effective, what their options are with regard to sale signs in their community. And so at this point, I would take questions and talk with you more about these political signs, solar panels, and sale signs. But if you do have questions, I do again suggest that you talk with your community manager and talk with the association's attorney to get more guidance and information on next steps. Thank you very much for having me.